Welcome to You and the Law. I'm Steve Cilente.
And I'm Bob Lally.
Bob, today I want to cover some viewers' questions. Viewers' questions are very important to us because that gives us ideas of things to research and to bring back to our viewers.
What people are interested in.
Right. We don't practice in a lot of areas of law. We're fairly limited. There's some very special areas that, like bankruptcy, that I know you don't practice, I don't practice. And it causes us to go back to the books, or at least to do some research to find out what some of these things are about.
Exactly.
But we need your questions. So even if we don't practice in the area of law that you have an interest in, let us know. Get a hold of the station through their website, send in your question. We'll do our best to answer it in one of our later shows, if we can.
And we'll learn something too.
I'm learning every day. Bob, one of the areas that is very important today, given the economy, there are a lot of foreclosures are going on. And while we don't practice, either one of us, property law when it deals with foreclosure, that's a very particular area. And I occasionally get clients who call about their property being foreclosed on. But probably the most common question I get is, I'm renting this place and I just got word that the property is being foreclosed on. What can I do?
Well, the primary obligation is to your landlord. You need to keep paying the rent to the landlord.
But once the property is foreclosed on, you have a new landlord, correct?
Correct.
So then what happens?
Well, it's up to the owner to resolve the foreclosure issue. But you need to make a determination of who it should be paid to, and that may be difficult at times. And if you can't, I would have a suggestion is you would maybe put it in a trust account and make it available to the appropriate person.
Let's back up just a little bit. Now, most often, a lot of times the people who are renting don't know until somebody knocks on their door and said, we're foreclosing on the property. And whoever's talking to them may not be giving them the correct information. They may say, you've got to leave right away, and that's not necessarily the case. But once they've identified who the new landlord is to be, when you talk about paying the rent, it goes to the bank or whoever the new owner or the owner of the property now is, correct?
The bank's going to know who the owner is.
Right.
No question about that.
Now, if it was a short sale where the bank has essentially taken it, but they immediately put it on the market at some reduced price, and you're still in there, once a foreclosure goes through and the short sale goes through, the new owner is then the landlord, correct?
Yes. Yeah. And again, it's a determination of who the landlord's going to be. And a couple suggestions. If you're having difficulty with that, go to the community legal service or an attorney. They can help you with the things.
Right. In this county, certainly we've got Resource Connection that may be able to assist you in deciding who you should pay rent to. What Bob talked about is, excuse me, putting the money in a trust account. What is a trust account?
Well, a trust account, attorneys have trust accounts, and it's where we hold our clients' money for certain purposes. It's not our money, it belongs to our clients. And that's why we call it a trust, because we hold it in trust. And it doesn't have to be an official trust account, but an account where those funds you don't use for your everyday purposes, but maybe you could let the bank know that these here are to make the payments on the rent.
Right. So in other words, if you're renting a property, you find out it's been foreclosed on, that or going to be foreclosed on, sending your soon-to-be former landlord the money may not be a good idea, but perhaps create a second account and deposit your full rent, water, whatever you have to pay into that account. So once the new owner is identified or the bank is identified, the money is readily accessible. Because if you don't, and they come knocking your door, say you've got to pay us and you're 2 months behind, you may be subject to eviction.
Right, and if they do come at your door, this is a very good point. It's just a practical point. If they say you're 2 months, you say, I have the money for you. It's right here in the trust account.
Right, or in a special account.
Yeah.
But at some point, somebody will collect the rent.
That's true.
But regardless of whether or not you know who the new owner is, you are still liable for that rent. But once you have notice that your rental property is being foreclosed on, the owner that you've been dealing with all these years or last few months is not the person you should be giving the money to.
True. Once you have proper, appropriate legal notice, yes.
Right. And also, whenever you're paying your rent, write a check, put in your memo section it's for April 2011 rent. If you pay cash, you better get a receipt.
Always get a receipt. I've seen that so many times with so many things that people have paid cash and they don't have a record of it, and it comes back to haunt them.
Right. And if you set up with your former landlord, for instance, that the money comes out of your account on an automatic deposit, in other words, a transfer of funds from your account to their account, immediately terminate that.
Right. Also, in this day and age in the economy, if you have some special arrangement with your landlord because you're paying on time or something, income comes in at a certain time or something, get with the new owner as soon as possible, or the bank.
Well, I think the situation we're talking about, you have a rental agreement that says that rent is due on the 1st, late on the 5th, and at some point later, you talk to the landlord, said, look, I don't get paid until the 5th. Can we make it due on the 5th and payable on late on the 10th? And the landlord says, yes, you've got to reduce that to a writing, because that oral contract may be good with your soon-to-be former landlord. It will not, you'll be held
to the terms and conditions
to
of
the
the
terms.
written lease.
That's right.
Absolutely.
So
that's really true.
everything dealing with real estate always should be in writing.
Right, and that's a tenet of the law, basically. It's
That's correct.
to be valid.
The only exception is month to month.
Correct.
Where every 30 days, essentially, you get to stay here for 30 days, you pay me, and at the next 30 days, we'll decide whether or not you get to stay.
Right, but what's very interesting about that is when you have the original lease, even though it may be month to month to month, it all reverts back to that original lease, to those
Right.
original terms and conditions.
My suggestion to people, my clients that have talked to me about renting property, always put it in writing. I don't care whether it's month to month, week by week. Put it in writing, put in all of the terms. I usually send them to a real estate lawyer who knows what to put in a lease. I mean, I could figure it out, but they don't need to be paying me for the time to research it, draft something, when somebody that practices real estate probably already has all of this drafted out.
And at the very least, go to the stationery store and get a contract and go over it with it, pay an hour to go over it with an attorney, maybe.
Nothing against stationery stores, but I put that one step above oral contracts.
I understand. That's why I said take it to an attorney.
Right. Now, even if you've got a lease, you're in the building, and it gets foreclosed on, the new landlord or the bank, irrespective of the lease, still can serve you, as I understand it, with a 90-day notice that at the end of 90 days, even though you have a lease, you have to vacate the property.
As a new owner.
As a new owner. Now, while I've never read it, it's my understanding that there was a law enacted in 2009, I believe because of the current economic situation, referred to as the Helping Families Save Their Homes Act.
I've heard about that.
I've only heard about it, never read it. Obviously, I don't practice in this area, so I don't need to be aware of everything that goes on out there. But the main point is, if you've got a written lease or a written contract and you think you're safe and the property's being foreclosed on, there may be situations where legally you can be told to leave or be evicted from the property.
Yeah. Yes. One of the things that act does, and I want to make people aware of this, if somebody just out of the blue shows up at your front door and says, you're losing your home, I can stop it, just give me $10,000, run, don't walk.
Right. That's a situation where you're the actual homeowner.
Right,
And
that's a little
someone is soliciting you, came to your door, wants to solicit you to save your home. Again, while I don't know much about it, I've certainly heard enough horror stories about that. And I understand that it's not legal for them to pay that person, the attorney, whomever, money to do that.
They have, I don't know exactly what it is, so I won't comment exactly, and I'd say whoever does this should check it out. But there have been great limitations put on taking money, particularly if you're a lawyer, in representing to people to stop foreclosures.
No idea. But it seems to
It's
make
out there.
sense to me.
Yeah.
And I'm not aware that there's, well, maybe there's some laws to assist people for that. I don't know about it, don't practice in that area, so go talk to a lawyer that does. Other unrelated interesting question that has come up from one of the viewers, Bob, is about how public defenders are hired or how they are contracted for. Now, this is kind of an area that you and I have seen, not necessarily dealt with directly. I've never been a contract public defender. I've been asked by the court periodically, can you handle this case because the public defender has a conflict of interest, whatever it may be.
It's kind of in the same manner as what we call an appointed attorney.
Exactly. And we use the word synonymously, essentially, public defender or appointed attorney. The California Penal Code, in Section 987, for those of you that know how to look this stuff up on the internet, 987 of the Penal Code lays out how counties are actually to do this. And it gets very particular, especially when you're dealing with large or small counties. Large counties, they typically will have a public defender's office that is truly an office. They're county employees. That's all paid for by the county. They have essentially the same benefits in terms of the deputy or the district attorneys do. But in these small counties, it's not necessarily cost effective to have one office dedicated to public defender.
Yes, it's great expense to maintain those offices, and oftentimes the counties will contract with third-party private offices to act as the public defender, but they're actually private attorney offices.
I've seen a number of different things, like I've seen in Amador and Calaveras, they actually contract with a firm to handle not only criminal cases, they may be involved in probate cases, they may be involved in juvenile delinquency cases, and perhaps juvenile dependency cases. So they may be contracted with to do a whole variety of things, but that's a firm. Other counties I've seen where they've got a number of attorneys on what we call a wheel, where the court will assign a case to whoever's in position number one, next case goes position number two, and they work it that way. They're not contracting with an individual firm, but individual lawyers.
Correct. And sometimes it's called a wheel, and sometimes it's just a flat panel.
Right. Now in Sacramento, they use a panel
It's
system.
a panel, and I know that the lawyers, they'll come down there for a day and they'll take cases for a day.
Right.
They have to set aside a whole day for that.
In Butte County, at least they were from years ago when I dealt with them, or one of my friends was up there, they had certain attorneys, they were all individual offices that were acted as the role as a public defender, but they had no other link between themselves. Amador County, Calaveras County, there's a single firm that handles almost all of the public defender roles.
Correct, unless there's a conflict.
Right. And then they've established in both counties an alternate that's the first level if of conflict, and if they need to, then there are individual attorneys that they can also appoint.
Right. I want to backtrack just for a little second. I want to clarify something. In Sacramento, they actually do have a big, very thorough and very good public defender's office down there. The panel we're talking about is in the conflict situation.
That's correct. You're right. They do have a public defender's office. When I was in Sacramento, met many of them, some very fine attorneys there, some very sharp attorneys there. And then they had the panel, the individual law offices that were there to be appointed cases. But in either respect, whether it's by contract, a panel, or a public defender's office, well, public defender's office run a little differently. But if there's a panel, or like in this county where there's an individual firm, every lawyer that participates as a public defender role or assigned attorney role, first of all, it's open to all members of the bar, but they have to pass qualifications approved by the judges.
Oh, it's true, and not only the judges, but sometimes the county agencies want certain requirements. They want attorneys at a certain level of experience to handle certain cases, and they actually have certain classes of attorneys in some counties, in the larger counties.
That's right. The fresh law school grad would only get minor crimes, but the person that had been around for quite a while might get a homicide case or something serious, some type of serious case.
True, and the judges are very careful about this in choosing the cases that they assign people. Even if you have a wheel or a panel situation, and you have a limited amount of attorneys, a judge might go to a private attorney that has more experience to handle a significant murder case.
That can happen. In the Amador and Calaveras counties, for the most part, I think the judges try to make sure that the attorneys who are on their panels or on the public defenders have a minimum, and I'm not sure what that minimum is, level of experience. Otherwise, they're not allowed to handle the case.
Correct.
Now, interestingly enough, that when a lawyer graduates from law school with zero experience, let's say they were pumping gas while they were going through law school, and they passed the bar, under California bar rules, they could essentially handle any type of a case in any field of law because they're licensed to practice anything. But the bar also says that you never take any type of a case that you're not competent to handle. Unfortunately, I think we've both seen situations where it's clear that the attorney, not because of lack of years, it may be just absolute lack of experience, really should not be handling the type of case. But fortunately, under the 987 rules, the judges can say, no, you've got to have this much level of experience before you handle a case.
You know, there's one real interesting exception to that. And that is, it isn't an exception that you should take a case that you're not competent to handle. But some lawyers that are young attorneys that come in will get their hands on a significant litigation case or personal injury case. What they do is they go out and they associate somebody in that has the experience and the firepower to handle that case. I've seen careers get started like that.
That's true. Now, in some counties, they offer training to bring attorneys up to a certain level. Certainly, the California Public Defenders Association, which is open to any non-prosecutor, offers a lot of training. California Appellate Panel offers training. I can't think of everybody that's out there that offers training, but regular public defenders' offices such as Sacramento, Los Angeles, San Francisco usually put on training for their staff only and teaching them how to handle, for instance, they may start off in doing DUI cases or small level misdemeanors, and then as they get more experience, then they're going through training for other more serious type of cases.
And they move up the ladder.
Right, but when it comes to private attorneys, it's really incumbent upon that private attorney to seek their training.
Right, and that's why we have mandatory continuing legal education in California.
Every 4 years, we have to report.
That's right.
And if you don't do what you're supposed to do, you don't get your license renewed.
One interesting point before we move on is that if an attorney says, I'm a specialist or something, there's only certain areas you can be specialized. We've talked about this before on the show. But one of them is a criminal law or family law or something like that. And he has to meet certain qualifications in order to handle those type of cases.
I see a lot of...
He or she, I should say.
Correct. You're politically correct. I see a lot of situations where you'll see advertisements where attorney says specializes in, we cannot use that in an advertisement unless we are board or bar certified as a specialist. A lot of attorneys don't go after that specialization because in some ways it can limit their practice.
True, and a lot of attorneys who aren't specialized are more knowledgeable than the ones that are specialized. That they've been doing it for years, they just haven't gotten specialized.
That's one of those areas I'll say, I'm not going there.
Okay.
But I don't disagree with that. But the bottom line is that the public defender, that whether it's appointed, is always under 987 of the penal code. The judges have control over who is allowed in their courtroom to be an assigned or a public defender, and it's really up to them. They can put it out on contract. The judges essentially set the criteria, how they want to do it. In Amador and Calaveras counties, of course, it went out originally on contract, and they've allowed that contract to go on, but the judges control it. To the extent where if that particular law firm hired an attorney and the judge did not feel that they were up to par, the judge could say, this person cannot work for your firm, at least in my courtroom.
It can exclude them from the courtroom.
Exactly. But on the other hand, they could walk out, come back the next day as a private practitioner and do that very same case, and there's not much the judge could do.
Judge can't do anything as long as they're licensed.
Although there are situations where I know that the judge has actually written to the state bar saying that an attorney is not qualified.
It's usually got to be a pretty bad situation for that to occur.
The one that I saw, it was bad. So anyway, well, the other one of the other viewer questions that we got was, and I've seen over the years, is somebody calls me and says, I've been working for John Doe for so many years and they're not paying me, or they're paying me late, or they're giving me a paycheck and said, don't cash the check because I don't have enough money in the bank. And of course, my usual response is, why are you still working there?
That's a very good question. The answer is the California Labor Relations Board.
Right. The
So you
short,
try to work it out first.
obviously, employers, I'm sure, run across problems from time to time, but where they can really get into trouble is if they don't pay their employees, because the employee, their rights are covered under the California Labor Code.
True. And not only do they have to pay, but they have to pay the employment tax. They have to pay the tax for the employees.
Workers' comp,
Yes.
they've got a workers' compensation, they've got to pay that. You've got to show that, you better show that's been paid. There are a number of things that have to be paid by the employer, and I've seen situations where employers get into very deep trouble because they've been withholding the money for themselves and not paying the state, not paying the employer's part of the taxes, which we all have to pay. But the problem really goes back to the employer. The employee has a lot of rights, but the first thing as I always tell them, why are you still working there? You need to call the local labor board, whether it's Sacramento, Stockton, I'm not aware of any local one, but they have to pay.
And I would, of course, recommend the website for a resource on that, the Labor Relations Board website.
That's correct. They are on the internet. I found it today. I was looking at some things. One of the things that I learned regarding the pay is that in California, with some exceptions, an employer must pay at least twice during any calendar month in advance, well, whatever the days are, whether it's the 1st and the 15th, every other week, but they've got to pay twice a month. Now that's, a lot of times you'll hear us refer to the general rule is. When we say a general rule, that means it applies to most everybody, but that means that also that there are situations where certain people are excluded or they are paid differently in this particular case, because there are some situations where an employer doesn't have to pay their employee twice a month.
We call those in the lawyer world exceptions.
They are, and there are exceptions to exceptions as well.
Correct.
But twice a month, you have to be paid, all right? And however the employer is paying the state, that part I didn't research. But there are also special rules that did you know that if you fire an employee,
You better have what ready?
paycheck ready.
That's right.
Now, if employee
In
quit-
hand.
In hand,
Sorry, yeah.
absolutely. If you're fired or somebody gets fired, that employer has to hand you the paycheck. Now, if there is a reimbursement check for per diem, or there's a bonus that they're entitled to, or overtime, I don't know about overtime, but holiday pay, that can come at a later time with regular payroll. But their actual salary or their wages must be paid at time of termination. But what about if an employee walks in and says, I quit?
That's an interesting question. I don't know. What is it, Steve?
Regular payday,
Regular payday.
right? I always encourage employers, if they quit, immediately have a check sent to them, just get it over and done with. But legally, you can wait to the next regular payday to pay that person.
That means if your employee, you'd probably be getting it in the mail, am I correct? Or you could go pick it up, which is better.
Whatever the arrangements are.
Yeah.
Now, overtime is got to be paid no later than the payday for the next regular payroll. Remember we talked about terminating
True.
someone?
Yes.
You certainly got to give them their paycheck when you terminate them, but overtime can roll over till the next paycheck. And it's really a topic for another show, but one of the complaints that I hear, and I refer people again to the labor board, is I'm working 12 hours a day or 10 hours a day, but my employer refuses to pay me overtime.
Okay.
Not in California.
You don't get overtime?
No, you work 8 hours, or you get
I've
paid
never gotten
overtime.
overtime, so I don't know.
Well, that's because you own your own business.
That's true.
We can work as many hours as we want,
Right.
and that's why I tell everybody I only work part-time
So, right.
because the rest of the time I'm sleeping or working. But overtime, California, there are very specific rules, whether you're working 10-hour days, now unless you're under like a 410 program. If you're working overtime, you're entitled to get paid for it. But if you're a contract person
Salaried
or working on a piece per piece, in other words, for every item you produce, you get X number of dollars. All right? That's a little bit different.
That's different, wholly different, because it's different structurally with the taxes too.
Right.
But that's another issue.
Exactly. We get into these exceptions. For instance, there's a group of employees are laid off by reason of the termination of the seasonal employment. Now, we have a lot of loggers up here, people that are working seasonal, and under the labor code, it also includes people involved in curing and canning and drying of certain perishable fruit or fish or vegetables, and they must be paid within 72 hours of the layoff. Again, it's one of those exceptions that when you're dealing with seasonal, you may not necessarily have to get a paycheck on the date that you were laid off.
That's interesting because of the seasons. They're
Exactly.
changing, yeah.
The other exceptions, labor is a big one, farm labor is. Also, if you're an executive or administrative professional, there are whole different rules that are
That means
applied.
salaried, am I correct? As
You may
opposed
be
to the-
salaried.
Yeah.
Right. So there are all kinds of different issues
Scenarios,
involved.
yeah.
We try to do our best to answer all of your questions, and these are many of the type of questions that we get. Get a hold of the station on the internet, send us your question, and again, we'll do our best to answer them. Thank you for joining us today on You and the Law.